Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing K-3, CR-1, and IR-1 visas, aka U.S. marriage visas. I'm thinking about this in the context of somebody who's married, a foreign national married to an American citizen, although this same analysis could apply to a foreign national married to a lawful permanent resident from the United States as well. I thought of making this video after reading a recent comment on one of our prior videos, quoting directly, "The USA has certain requirements as well known as the public charge rule. This is not really enforced." I would say that that's not the case. The public charge rule is enforced. We have had to deal with the public charge rule, especially in the context of IR-1 and CR-1 visas. Regarding the K-3, as we've discussed in other videos, as a practical matter, K-3 visas are not really processed with a great degree of regularity due to what's called administrative closure policies at the National Visa Center. It's just been our experience, especially as of late, that the K-3 is just not something you see very often. What we do see quite often, though, is the IR-1 and the CR-1, and those visas processed through the National Visa Center, and believe me, public charge is a major issue when dealing with NVC, and it can become a major issue in consular processing when going through adjudication at an embassy or consulate abroad, because they have to be sure that that immigrant, that intending immigrant, is going to have some form of material support when they arrive in the United States. The concern being they don't want immigrants to come into the United States and then go on means-tested benefits therein, aka welfare. They don't want people to travel to the United States, immigrate there, only to go on state benefits. That's the real concern. And public charge rule issues are oftentimes the biggest concern on the back end of processing of immigrant visas, especially. It's really one of the biggest issues we deal with when trying to get an immigrant visa processed. And frankly, both the staff at the National Visa Center, who I've been critical of in certain contexts, especially sort of from an admin standpoint, they often ask for they make a lot of redundant requests, especially in light of the fact that much of the documentation that is sometimes requested has already been submitted to the Department of Homeland Security. But leaving that aside, adjudicators at embassies and consulates, when they make public charge inquiries, oftentimes, it's been my experience that it's pretty reasonable requests. They basically say, hey, look, this person doesn't meet the income requirement, for example. Can we see some assets to offset that deficiency? Usually that's pretty easily proven, or at least it's proven in a straightforward manner, or you can deal with a joint sponsor. But I don't usually see those kind of requests, for example, in like a 221G request for further documentation. I don't usually see that where it's sort of issued wantonly. A public charge rule request is sort of noted just out of nowhere. They've usually got a pretty good leg to stand on for requesting information associated with the public charge rule. But make no mistake, in an immigrant spouse visa context, yes, the public charge rule is very much enforced.